Good afternoon. I am Jennifer Lowe. I'm the Director of Programs and Strategic Planning here at the Supreme Court Historical Society. I'm delighted to welcome you to our virtual platform for today's program on the legal career of Ruth Bader Ginsburg. Due to the size of our esteemed panel and their terrific insights into the justice that we want to hear, I'm going to keep my opening remarks very brief. Today, we are joined by 4, hopefully 5 panelists with connections to Justice Ginsburg. Long before she joined the Supreme Court, she was a rock star lawyer and advocate. Today, we will be hearing from Sharron Cohen, who was the plaintiff in Frontiero v. Richardson, a landmark case in the world of women's civil rights. Joe Levin, who represented Sharron at the Supreme Court and went on to co-found the Southern Poverty Law Center. Stephen Wiesenfeld, the litigant in the Weinberger v. Wiesenfeld case, who developed a decades-long friendship with Justice Ginsburg. Professor Phillippa Strum, who is a global fellow at the Woodrow Wilson International Center for Scholars, is the center's former director of the Division of United States Studies, as well as a political science professor emerita at the City University of New York. She is the author of On Account of Sex, Ruth Bader Ginsburg and the Making of Gender Equality Law. Amanda Tyler, who is the Shannon Cecil Turner Professor of Law at the University of California, Berkeley School of Law. She's the co-author with Justice Ginsburg of Justice, Justice, Thou Shalt Pursue, a life's work fighting for a more perfect union. Professor Tyler clerked for both Justice Ginsburg and Judge Guido Calabresi. We hope to have time to take questions from the audience, and you can share your questions in the Q&A box on your Zoom window. Professor Tyler, the floor is yours.
Thank you so much, Jennifer. It is such an honor to be here, especially along with my fellow panelists. I have to say in particular, it is just such a privilege to be on a panel with Sharron and Stephen, whose cases I have studied as a law student, I've taught as a professor, and who I've had the privilege of talking about with Justice Ginsburg. So I'm just really thrilled to be here. As you heard, I had the honor of serving as a law clerk for Justice Ginsburg from 1999 to 2000, and I had the great joy and privilege of working with her on a book about her life during what wound up being the final year of her life. So it was just really a special privilege to get to work with her on that and talk with her firsthand about her legacy. Now, one of the things that I've said many times, and I think this panel highlights, is that if Ruth Bader Ginsburg had never sat on the Supreme Court at all, we would still be talking about her because of what she did in the 1970s. It was so important, and it changed the social and legal landscape of this country for the better. Now, in order to set the backdrop for the 2 cases that we're going to study here today, I want to talk a little bit about the state of the law before the 1970s. Throughout the 1960s and the decades that preceded it, the Supreme Court upheld legislation drawing distinctions between men and women. Indeed, in the early 1960s, the court upheld a law that excluded women from jury pools. In the case of Hoyt versus Florida, the court, in upholding that law, said, despite the enlightened emancipation of women from the restrictions and protections of bygone years and their entry into many parts of community life, frequently considered to be reserved to men, woman is still regarded as the center of home and family life. We cannot say that it is constitutionally impermissible for a state acting in pursuit of the general welfare to conclude that a woman should be relieved from the civil duty of jury service unless she herself determines that such service is consistent with her own special responsibilities. In other words, the court viewed the woman as at the center of home and family life. Against this backdrop, perhaps it is unsurprising that when Justice Ginsburg was a young girl, she did not even contemplate becoming a lawyer or a career in the law. As she told me when I interviewed her in 2019, I didn't think about the legal profession because women were not there. But she did become a lawyer. And by the onset of the 1970s, she was also a law professor, first at Rutgers and then at Columbia. Spurred on by her students, no less, she created a class and later published the very first casebook on sex discrimination and the law. Meanwhile, Justice Ginsburg, then Professor Ginsburg, also served as director of the American Civil Liberty Union's Women's Rights Project, and later as one of the ACLU's 4 general counsels. In that capacity, through a series of carefully chosen cases, Justice Ginsburg toppled the stereotypes and assumptions that had provided the foundation for cases like Hoyt versus Florida and earlier cases like Mueller versus Oregon and Gosart versus Cleary. It began as those who have seen the 2018 movie written by her nephew On the Basis of Sex, with a case she jointly litigated with her husband, her beloved husband, Marty, a case in the 10th Circuit called Moritz versus Commissioner of Internal Revenue. The effort began when Marty, a tax lawyer, showed his wife some pages from a tax court advance sheet after seeing a report of Mr. Moritz's case. Now, as the justice tells it, she said to Marty, "I don't do tax cases." And he said, "I think you'll do this one." In short order, she agreed, and they took it, and they prevailed on behalf of Mr. Moritz in the 10th Circuit, a never married man who had been disallowed a caregiver tax deduction. His female equivalent would have been allowed. Mr. Moritz wanted to take care of his mother. But the Moritz case proved not just a victory in the 10th Circuit, but also to be, as Justice Ginsburg once told me, a pearl beyond price, a classic Ginsburg phrase. This is because when the government sought Supreme Court review of the Moritz case, it attached a list to its brief of every single federal law that discriminated, or I should say drew distinctions based on gender. Remember, this is before the internet. This is before modern computers took off. It was a roadmap for the justice and her team at the ACLU of all the laws that they needed to see changed through litigation, or as she told me, preferably through legislation. In any event, they wanted that change, and now they had their roadmap. In their brief in Moritz, the Ginsburgs argued that Mr. Moritz should prevail under existing standards, but also they pushed the appellate court to move beyond those standards and apply heightened scrutiny to gender-based distinctions in the law. Indeed, they contended that laws discriminating based on gender should receive the most rigid scrutiny from a court, no less than the scrutiny applied in cases of race discrimination. The Ginsburgs likewise argued in their brief, setting the stage for the cases that followed, and specifically the 2 cases we're going to talk about today, that fair and equal treatment for women means fair and equal treatment for members of both sexes. Throughout the 1970s, Justice Ginsburg briefed 10 Supreme Court cases on behalf of parties challenging gender discrimination, presented oral argument in 6 of those cases, and prevailed in 7 of the 2 cases. But as she pointed out to me when I talked with her about these statistics, it's really 8, because one of the cases became moot during its time before the Supreme Court. Justice Ginsburg also filed amicus briefs, or friends of the court briefs, in almost, or at least a dozen more cases. Now, we will hear more about 2 of the cases that she argued before the court, and they were her favorites, Frontiero and Weisenfeld. Indeed, when we assembled the book together about her life and career, she told me that those 2 cases were her very favorites that she argued to the court. And she insisted that we include coverage of both cases because of that. Frontiero, as we'll hear, was the first case she argued before the court. And there she highlighted, historically, women have been treated as subordinate and inferior to men. Although some progress towards sex discrimination has been made, the distance to equal opportunity for women in the United States remains considerable. Considerable indeed. And so Ruth Bader Ginsburg set to work. During the 1970s, she successfully challenged in litigation before the Supreme Court and lower courts, among other things, a statutory scheme that preferred men to women as estate administrators, the automatic discharge of pregnant Air Force officers, federal statutes granting disparate benefits to male and female members of the military, as we'll hear, the automatic exemption of women from jury pools. In effect, she saw Hoyt versus Florida overruled, the denial of equal Social Security benefits to men and women caregivers, as we'll hear, the denial of unemployment benefits to pregnant women, the denial of equal Social Security benefits to male surviving spouses, and the limitation of assignments available to women in the Navy. This is to say nothing of the many legislative accomplishments that the Women's Rights Project achieved, including, among other things, Title IX and the Pregnancy Discrimination Act. In 1980, President Jimmy Carter took Ruth Bader Ginsburg, the advocate, and nominated her to be Ruth Bader Ginsburg, the judge. The Senate confirmed her to the DC Circuit, and in 1993, President Clinton nominated her, and the Senate confirmed her, to the Supreme Court. All told, she served as a federal judge for 40 years, 27 of those years on the High Court. In total, she wrote over 700 opinions on the DC Circuit and some 480 opinions on the Supreme Court. The latter included 153 dissents, which she once said, speak to a future age. Now, I will say more about the connection between her advocacy and her later time as a justice on the Supreme Court. But for now, I'd like to turn it over so that we can hear more about the Frontiero and Wiesenfeld cases.
Thanks, Amanda.
Oh,
No, Sharron, I absolutely, first of all, I must tell you, it's a great honor for me to be here with you and Stephen. I mean, having written about the two of you, never having met you, I'm just delighted to do so now. Sharron, I think what Jennifer wants us to do is for me to kind of set the background and then for you to chime in, of course, and talk about what it felt like to you. So Sharron was in the Air Force, was a physical therapist in the Air Force, and she and her husband, Joe, she was working at the Maxwell Air Force Base with her husband, Joe, and they wanted to live in a nice place and discovered there was no room for married women officers and their families on base. They would have to live off base. And then they discovered that while married male officers living off base got a stipend, women married officers did not, unless they could prove that they were responsible for more than 50% of their husband's support. And the way the Frontiero's incomes worked, while Sharron was the major breadwinner of the family, she did not provide more than 50%. And so the question was, is this fair? Is this not discriminatory? Because men who were given stipends to live off base with their families did not have to show that they provided more than 50% of their spouse's support. So Sharron, why don't you jump in now and tell us what it felt like to you?
Oh, I was ticked off. But can I say one thing? Stephen and I both share a first for Ruth Bader Ginsburg because my case was the first one she argued in front of the Supreme Court, but she was not my lawyer. Joe Levin was my lawyer. She was the ACLU lawyer who argued a brief. Stephen was her first client in front of the Supreme Court. And over the years, that's caused confusion. So that, yes. But you wanted me to talk about
case she could control the case from beginning to end is what the difference is. Whereas when Joe was your attorney, he was really in charge of the way the case would move. Ruth was second, but she had complete control of my case. There was nobody else involved in it.
Well, it depends on whose office you walk into. I walked into Joe Levin's office and said, will you help me with this? You walked into her office, right?
I did not walk into her. I wrote a letter to the editor and got an introduction to her from that letter.
Yeah, I don't think that particularly I don't think it was because he was a man and she was the woman that she was in the second seat. I mean, I went.
No, I wasn't saying
to
that.
Oh, okay, okay.
I was saying that you had hired Joe first.
Yes.
He was the person that you were working with.
Yes, yes. And I think they worked very well together, because the other thing that's confusing about the case is how the justices split their vote. And it was 8-1 in favor of, women's equity in the military. But the 8 justices who voted, 4 voted on the basis of Joe's argument, and the other 4 agreed on the basis of Ruth Ginsburg's argument. It's a very confusing thing. I was hoping to have my lawyer here today to explain it all to you, but I don't know where he went.
And Rehnquist was a lone dissenter
Yeah,
in your
yeah.
case.
And then I understand that he came around later in life, that there was a case in which his daughter was being treated unequally, and that he came around to see the more feminist view of things. I've been told that. Joe, here he is.
You're muted.
Unmute. Right.
Okay, sorry.
Oh,
I
okay.
think I signed on to Zoom in the wrong way, and I could see you guys talking, but I couldn't. You couldn't hear me. I'm sorry. Apologies.
Okay.
But I'm here.
Okay.
Okay.
Well, thank God you're here, because they're asking me legal questions, and I said I was going to bring a lawyer.
All
And
right,
where
hang
were
on.
you?
My computer just made me put my code in again.
Okay.
This is the trouble with being old and not understanding electronics. Okay, there we go.
Okay.
I think I'm back pretty much at this point.
We're talking about my case, your case.
Yeah, I heard it all. I heard.
Oh,
the
you did? Okay.
Yeah.
Okay. So I think Phillippa Strum asked me, did you ask me how this started?
Well, I asked you how you felt about the whole thing. Sure, and that's part of it. Absolutely. What led you to decide that you wanted to bring the case rather than just accept what was being done to you?
Oh, I was pissed. I was really pissed. I was, I wanted the money. It was the equivalent. The housing allowance was the equivalent of 1 week's pay, 1 extra week's pay every month. That makes a difference when you're young. Makes a difference when you're old too. So I wanted my money, and in the course of trying to get it, I went from office to office all around the air base talking to people, and was really getting insulted. You don't belong here. I don't know why women think they can be here. Your husband, what's wrong with your husband? Why isn't he supporting you? And it just got really frustrating. And it was actually my husband at a certain point who said, enough of this. There's a law firm in town that does work with civil rights. Why are you continuing to go from one person to another, hearing the same thing over and over again? So we went to Levin and Dees. Dees was off on the McGovern campaign. And Joe was really the first person. I think that people must have told me before. I've said this before. I was very naive. At the age of 24, I was very naive. And it just took a long time for me to understand that this was gender discrimination. These guys just don't understand it. There's just something wrong. And when I went to Joe, he said, no, they understand it perfectly well. It's a statute. And the only way that you're going to change this is if you're willing to go to court and sue to change the statute. So that was a real new thought for me. I had to kind of consider that for a few seconds. And then by the time I didn't know this would go to the Supreme Court. Had I known at the age of 24 that this would end up there, I might not have pursued it. Just by the time you're, in the big muddy up to here, well, you're in the big muddy up to there. So that's the short answer is I was pissed off and I wanted my money.
You said that.
Yeah.
That you're pissed off. All right.
Why did you take the case, Joe?
Well, we had just started the law firm within the previous year and a half. I got out of the Army in '69 and got back to Montgomery then. And long story short, Morris and I started a law firm, and we started it in order to do civil rights work. We're mainly concerned about issues related to race, because that was the really big issue, certainly during the '60s and early '70s. Who knew that it would arise again in such a way in the 21st century? But we, so that's the kind of cases we were doing. And we had litigation going on then against the state of Alabama for multi-member districting its House and Senate in order to avoid having blacks elected. We sued George Wallace's cops, the Alabama State Trooper Force, which was all white, and a number of other cases that we were doing, primarily based upon race. Your case was the first case that related to discrimination against women that we had seen, or quite frankly, to be perfectly honest about it, it wasn't at the forefront of our thinking at the time. And although you talk about what you would not have done, I remember very distinctly that you had gone through an entire process of talking to all kinds of people above your rank to try and get some of that changed. So you showed, as far as I was concerned, once you described to me what was going on, you had really impressed me with the courage that you'd shown and your willingness to pursue it further. So there's so much more that could be said. I'll leave it there unless there's something else, Sharron, that you'd like for me to say about how it all started.
Well, I'll just jump in and pick up on something you said, Joe, that your firm was dealing with race cases because that was the big issue of the time. And I think what we have to thank RBG for, among other things, is that she made it clear that that wasn't the only big issue at the time, that in fact, everybody should be looking at what she first called sex discrimination and later on gender discrimination, the same way they looked at race discrimination. And it was her willingness to take that argument to the Supreme Court that ultimately, as Amanda said, changed the law of the United States.
Exactly right. And it was not until I was contacted by the ACLU that I was even aware that the Women's Rights Project existed. Remember, we're talking about, for us, we're talking about Alabama. The issue in Alabama then was clearly the high profile issue was race. The Women's Rights Project, which, and I think Ruth initiated that, correct? And she ran it. That was something I didn't know until I got this call from Mel Wolf, who was the head of ACLU at the time, and we had a discussion about that. And it wasn't, and at that time, we were, at the time I heard about it, the case, we had already filed a case, and it proceeded. And I think by that time, we had started the Southern Poverty Law Center, which was, as I recall, June of 1971. So the firm was no longer Levin and Dees. The firm, we were operating out of the Southern Poverty Law Center.
Yeah, well, at this point, unless anybody has anybody else to say about this case, should we just talk about Ruth's argument and then move on to the next case? I mean, just as I think, and Amanda, you said this, that it was Ruth's first argument before the Supreme Court. She had been I think the most important author on a brief in a case that preceded it, but she hadn't argued in the court. And she was still a relatively young lawyer. She didn't eat anything the day of the argument because she was afraid she would throw up from nerves. She wore her mom's jewelry as kind of good luck charms. And she prepared, as anyone arguing before the Supreme Court does, not only the speech that she hoped to give, but she had to figure out what were the most important points to make, because any of you who have seen an argument before the court or have read about it know that the justices jump in with questions whenever they feel like it. And so you can't just go with your prepared speech. You'll run out of time and you won't have made your important points. So she prepared very carefully and got up to speak. Joe, you and Ruth split the time for argument. She had 15 minutes.
Yeah.
And she got up.
Yeah,
And
to be
she
exact.
kind of waited. Yeah, she waited for the justices to start asking questions. And there was total silence in the courtroom except for her voice. The justices didn't ask a single question. And when her time was up and she sat down, she thought, well, they thought that what I had to say was so unimportant that they didn't even bother. And happily, it turned out that that was not the case. Yeah, what did you think of the oral argument, Chuck?
What?
Yes,
Okay.
you asking me?
Yeah, what did you think of the oral argument?
Well, actually, it's a long story. There were lots of confrontational issues that led up to the ACLU, the Women's Rights Project, really, and Ruth. Not so much confrontation with her, but I was not a huge Mel Wolfe fan, so we weren't getting along very well. But with her, I was really surprised because just the evening before the argument, my ex-wife and I had dinner with Ruth and her husband Marty at a restaurant at what was then the Capitol Hill Hotel, no longer exists, and very close to the courthouse. And it was we had absolutely no discussion of the case. In fact, most of the time was spent listening to Marty, who was one of the funniest guys I've ever been around. He would, and so it was a very relaxing evening, a couple of hours of eating and talking, and that was about it. Most of the talking by Marty, which was a good thing. And but given everything I knew about Ruth and the way she had prepared for it from previous discussions, I was really surprised that there was not a single question asked. They had grilled me, and I thought, okay, she's going to be arguing strict scrutiny, which I did not argue. Another story, because we were concerned that we thought that rational basis was certainly sufficient to get the court to rule, and we didn't want them spending a lot of time debating over strict scrutiny. In any event, so I thought, surely, given that she's making such a strong argument for strict scrutiny, something with which I agreed, by the way, I just didn't think it was the best time to do it for our case. Nothing. They asked absolutely no questions. I wouldn't say I was shocked, but I was definitely very surprised, and I had thought about that over all these years.
All right, well, thanks for that. I think maybe we should go on to Stephen's case, because we want to leave time at the end for people in the audience to ask questions or make comments or whatever. Stephen, do you want to start us off by just talking about how you happened to decide there was something wrong with the way you were being treated?
Well, in background, my late wife Paula passed away during childbirth in 1972, and she had been a school teacher for the past 7 years prior to her death, and she paid top dollar into Social Security system, just like a male similarly situated teaching beside her, who earned the same amount of money, would pay the money into the Social Security system the same way. If he had passed away, there would be a Social Security benefit to the wife called a mother's insurance benefit. But when a female passes away, even though she did the same work that the male did, there is no benefit that it would accrue to the surviving widower. And so there's obviously brought up the question to me as to where is the money that my wife Paula had paid into the system? Where is it going? If it's not going to support her family, and why is her salary? It's like a discount to her salary because she wasn't able to use all the money or get any benefit out of an insurance policy or the Social Security system with the money that she had paid in. So there were that was one argument, was that there was this what was going on was discrimination against the females because their money wasn't being paid to their survivors. So went down to the Social Security office to ask for this money because I was entitled to a death benefit, and also because my son would be entitled to a dependent child's benefit. So the clerk at the Social Security office said there was no such thing as a father's or a widower's insurance benefit. And I said, well, what if I filed a claim and went to whatever things you might do, arbitration or something like that Social Security might do when somebody objects to something. And he said, there's no such form to file anything with. They had no forms that related to anything like that. So a couple of months later, there was an article in my local newspaper. I was living in Edison, New Jersey at the time. Ruth was teaching at Rutgers part of that time. And the New Brunswick Home News was a newspaper that was local in the area. So I wrote a letter to the editor dealing with alternate lifestyles. And I said, in that letter, I just said, just described what the problem was. And I asked at the end, I wonder if Gloria Steinem knows about this. So one of the little odds and ends that Ruth and I lived with for all the years afterward is that she always tells this story, and she says to the interviewer, I wonder if, that I said in the letter, I wonder if Gloria Steinem knows about this, and points her finger and says it in an elevated voice, when it was not my intention in the letter that I wrote. I told her that was not my intention, but she kept on doing it anyway. She wanted to make the point. Anyway, Phyllis Zaitlin Boring, who taught at Rutgers University along with Ruth, I knew Ruth. They actually started an organization together called WEAL, Women's Equal Action League, wrote to me and asked me if I wanted to pursue this further. And I said, that happens to be the exact reason why I wrote the letter. I wasn't meaning to say anything. I wanted somebody to give me some direction as to what to do. So she said she would put me in touch with somebody from the ACLU. And a couple of weeks later, Ruth called me, and that's the first time that we had a conversation or met each other. I actually, Sharron, was never in her office at all. All our conversations had to do over the phone or through letters, and I did go for something with the opposing United States attorney. And I think Kathleen Paratus was there with me. It wasn't Ruth that was there with me. It was Kathleen. I believe it was Kathleen that was there with me. I also think that when I first actually met Ruth, we were getting on to the train. She got on in New York. I got on in Edison, New Jersey. And we both rode down the train together to Trenton. And that's the first time that we actually laid eyes on each other. So we had already been in touch with each other for about 4 or 5 months, because she filed the case in February, and it was heard at the 3-judge federal panel in Trenton in June. So that's the beginnings. And sometimes I'm asked, Sharron, but
I have a question about that train thing.
okay.
Did one of you wear a flower in your lapel? You never set eyes on her, but you knew how to find her on a train? How did that
It
work?
was easy. It was easy because she was with I think she was with Kathleen. I'm not sure. I don't remember clearly who she was with, but she had one of her students with her, and they were carrying all these big briefs and big briefcases and papers and things like that.
Okay. So they looked
And
like lawyers.
And they were, well, yes, they were dressed properly and
Okay.
as you would appear. And back in the day, that was we were in front of that court in June of 1973. Women were not allowed to wear pants, so you had to have skirts or dresses or something like that. You don't remember that time because you probably didn't get involved with that. Anyway, they had these various restrictions. Is that a correct thing from what you know, Philippa or Amanda?
No,
Do you remember a period of time when you?
You're exactly right. And if
Yeah.
I could pick up on something, 2 things you said, Stephen. One, that she had a student with her, and I think it's important to emphasize that she used the students in her courses and also students at other law schools to help out on the cases that she brought before the Supreme Court. The Women's Rights Project didn't have a huge staff. Obviously, all of these cases required a lot of work. And so she used those students, and in doing so, in effect, giving them a clinic experience. She helped create a great mass of women lawyers who would go on to very distinguished careers themselves. And so her vision was not just, oh, I want to win these cases. It was, I want to create something for the future so that there will be women and men fighting against gender discrimination. And so when she got to the Supreme Court, picking up on something else you said, Stephen, when she got to the Supreme Court and she opened her argument as you do, Mr. Chief Justice, and may it please the court, she did not then go into the legalities. She could have talked about the precedents up to that time, whatever, but what she did, and you can see the transcript online, the transcript of the first page of her argument, where she started by talking about you, Stephen, and saying here was a man who was being discriminated against. And then she went on to talk about Paula, your late wife, and said, here's a woman who's being discriminated against, because just as Stephen would have gotten those child and care benefits had he been a woman, so Paula, had she been a man, would have known, yes, she's providing for her family in case anything happened to her, but her family was now being denied those benefits. And finally, Ruth went on to talk about Jason Paul, the little boy, saying he's being discriminated against because he is being denied the care of his sole remaining parent. And when the decision was handed down, lo and behold, some of the justices said, oh, this is a case of discrimination against women. Some of them said, this is a case of discrimination against men. And some of them said, this is the case of discrimination against the child. So the argument that she had made was absolutely reflected in the way the court handed down its decision.
Only one justice said it was discrimination against the child, and that was Justice Rehnquist. It was the first time and only time that he ever voted with Ruth Ginsburg. He would dissented on all her, I believe he dissented on all her other cases before the court.
It was probably talking about an embryo. That's an Alabama thing. I did want to point out that in the early 1990s, one of our lawyers was arguing a case here in Montgomery, actually before a U.S. magistrate judge, federal case, and she wore pants into the courtroom and was instructed by the judge, who was interestingly a very liberal magistrate. She was instructed to go home and change and put on a skirt.
Yes. So that was even, their dress code was enforced even into the 1990s. Yeah. You know, I wanted to go back, as Sharron was talking about going into the offices in the Air Force and being told that you shouldn't be there, or what is she doing here, and things like that. The justices, the Supreme Court justices, before my case was heard, were also wondering what I was doing in that courtroom. They thought it was disgusting that a man would actually even think about raising a child. And they had a conversation between them, and several of them spoke up about that. And that, after the case was heard and they were talking about it in conference, that idea even spread to their clerks and other people around. That naturally kept a secret all that time. But Lauren Moxley, an attorney in DC, was the one who somehow dug up all this information. And actually, I have some recordings of the justices demeaning my abilities to raise a child because I was a male. And Ruth was sort of she called me the night before we were going into the courtroom, and she was telling me that she expects a 4-4 decision without too much work to get that 4-4 decision. That William O. Douglas was ill at the time and wasn't sitting, so there were only 8 justices at the time. And she said to me that she was going to direct all her words and quotes and things like that right at Potter Stewart, because she wanted his vote, and she wanted to have a 5-3 decision instead of a 4-4 decision. And Potter Stewart was one of the justices that several people had wrote about as being totally against the idea of a male raising a child. And there are other justices that she knew would vote against her. But it was a young woman who was Justice Brennan's clerk. The first time that he ever had a woman for a clerk, reminiscent back in 1973, 1975 now in front of the court. And there weren't too many women clerks at that time. I'm not sure if Marcia Berzin was the first woman clerk, but she later became a federal judge in the Ninth Circuit. But she was the one who actually changed the justice's mind and brought them to the unity decision, 8-0. And basically what she did was she was having a hard time writing the opinion for her judge, and Brennan, and went in for a clue that Ruth gave her. She said, dig into the Social Security law. And that's what she did. And she found out that the Social Security law was actually written not to protect or to help women. It was there to protect the child, the children. And so when she presented that in the argument that her judge was making, they all eventually came around to that opinion, because now they were not protecting or discriminating against a female. Now they would be discriminating against a child, and it made a big difference. Did you ever come across that? Three of you are attorneys. Did you ever come across this idea with Marcia Berzin and what she had done? I'd never seen it in writing before, but it was given to me. The information was given to me by Fred Strebe from Yale University in the research that he had done for his book called Equal, when he was working on that. And that was interviewed me in 1993, but the book didn't come out until 2009, 16 years later. So anyway, in the galleys of that book, when Ruth and I both got them at the same time, and we were learning some things about each other that we hadn't known before. Ruth had not known that I had put myself in a position to be able to be in that courtroom, because the United States attorney said that I don't belong in that courtroom because the minimum amount of restitution had to be at least $10,000. And that would not be the case here, since at the particular time I was in the room, I was gainfully employed, earning more than 10 times what the Social Security Administration would be paying me on a monthly basis, on a monthly benefit. And I was concerned that they would throw the case out. So I managed to lose my job and change my lifestyle, and became eligible to actually be in that courtroom. And she didn't know I did that just so that she could continue the case, because certainly the benefit wasn't going to improve my life that much. So and I learned about her is that I had become her first case. I didn't know that I was her first case from beginning to end, as I mentioned before when Sharron was talking about it. First case from beginning to end in front of the Supreme Court. So end product was somebody just prompted me to say the Supreme Court just now. That was my lovely wife, who Ruth married at the Supreme Court in 2014. You want to come over and put your face in a picture here? So,
Okay.
this is my wife, Elaine.
Hello, it's good to see you all. Hello. Hi.
Jennifer, do you want to throw this open to the audience now, or shall we go on?
Jennifer, you're muted.
I'm going to throw it to Amanda, and then we'll take it to the audience. So,
Well, I could sit here all day listening to these two talk about their cases, and I hope one of the audience members will ask Sharron and Stephen to talk about when they found out that they'd won, how that felt, because I would love to hear that. But in the interest of bringing this conversation full circle, as I said at the outset, I thought I would say a few words about the tie between Justice Ginsburg, the advocate, or Ruth Bader Ginsburg, the advocate, I should say, and Justice Ginsburg, the Supreme Court Justice. There's a case we didn't talk about that is actually very important to that trajectory from the 1970s, and it's a case called Wertheimer. The justice came in and helped work on a case called Wertheimer that came out of the Third Circuit and went to the Supreme Court in the 1970s. It was a case that involved two high schools for high-achieving students in Philadelphia. One high school was for the boys, and one was for the girls. Unsurprisingly, probably to many at the time, the boys' high school had more resources, more STEM classes, better opportunities, better, not necessarily better faculty, but faculty with more degrees and various other marks of prestige. And some girls said, I want to go to that school. I want to take more math classes and other things. So they brought a suit. And they won in the district court. The district court recognized gender discrimination in the arrangement, but they lost in the Third Circuit. They lost, and the Third Circuit reversed the finding that the schools were not equal and that was problematic. So the case went to the Supreme Court. And at that point, the ACLU came in, and Justice Ginsburg helped usher the opening main brief. In fact, she mainly wrote it for the Supreme Court. But she and the original lawyer on the case had a very different view of how the case should be litigated. And in that case, that different view led to a disagreement that ultimately led the local or original counsel, I should say, to ask the ACLU to leave the case. And so the original lawyer herself wrote the reply brief and argued the case. Justice Ginsburg did not argue the case. I've always wanted, I'm a big fan of counterfactual, so I've always wondered, what if Ruth Bader Ginsburg, with her amazing track record, had argued Wertheimer? But she didn't, and the court wound up splitting 4-4 in the case. And what happens when the court splits 4-4 is it affirms the judgment of the lower court. In other words, the girls who wanted to go to the boys' high school lost. Now, Justice Ginsburg, when she talked about Wertheimer, would always emphasize that loss was not precedential, which it isn't, because the Supreme Court didn't actually decide the case. They simply divided and left the lower court opinion to stand. but that loss aided her, and it aided her for decades. So fast forward to 1996, when she is now on the Supreme Court, and the court has before it a case involving the Virginia Military Institute that involved many of the same facts. You had VMI, which only admitted male cadets and had an esteemed faculty, amazing resources and opportunities, and a lot of, among other things, STEM classes. When sued, the state of Virginia said, we'll create a separate institution for female cadets. It was not as well resourced. The opportunities and educational opportunities, in particular at the proposed new female college, would not have been the same. And the prestige and alumni network was not the same. There was nothing about the proposed new female college that would have been remotely on par with VMI. And there, writing for a court, the justice held that Virginia was violating equal protection and VMI had to open its doors to female cadets. Now, she liked to tell the story. Marty kidded her at the time. My goodness, you're still litigating for Chimer 20 years later. And maybe in some respects that was true, but she took special pride in having the opportunity to write for the court in a case that effectively overruled Forchheimer, one of the losses that had eaten at her all that time. And I should note, in keeping with some of the things that we've discussed, she was also especially proud of the fact that then Justice, now Chief Justice Rehnquist, joined the judgment of the court in that case, joined the outcome in VMI. So what we see is a justice who played the long game. Her work from the 1970s very much influenced all that she did, even when she became a judge. And that work in fighting for gender equality is something that transcended her entire career. And that was really a defining feature of who Ruth Bader Ginsburg was and how she lived her life. So Jennifer, if you think it's a good time now, we can open it up to questions. Jennifer, you're muted again.
I'm not good at this. Stephen, we had one question about the book you mentioned, and if you could type the title and the author into the chat, I can distribute that to the audience. That would be terrific. One question we have from the audience is about the justice's legacy and the legacy of the Frontiero and Wiesenfeld decisions. What do you think the current generation of young women should know about these cases?
Well, certainly what young women should know about these cases and the whole range of cases that Ruth and so many other lawyers litigated in the 1970s is that there was a fight to get sex equality in the law. And I think many young women today are not really aware of that, you know, when Ruth started litigating, and when she looked back at what the Supreme Court had done in turning down cases that said we really need to have women allowed to be on juries and allowed to be lawyers, etc., what she would say is the Supreme Court back then never saw a case that discriminated, a law that discriminated against women that it didn't like. And that was very much the situation at the time she began litigating. And certainly, I think that's something that young lawyers and other people, not even so young and not necessarily lawyers, should know today, that it was a fight. And as I think we know from current events, the fight is a never-ending one.
I would like to say that I don't consider my case the most important one that came out of 1973, or Stevens. The most important one was Roe v. Wade. And we've lost Roe v. Wade, and we can lose everything else. That's what I'd like young women to know now. Now everybody's somber.
Question for Sharron and for Stephen. When you were going to the Supreme Court, what was your expectation as to the result?
We lost in the lower.
Who are you asking for? Sharron, you're answering first?
Hello? Do
Sharon?
you want to go
Let's have
first?
Sharron answer
Sharon?
first.
I'll defer to you.
Okay. All right, okay. Because I spoke with Ruth the night before we were supposed to be there, and she was telling me she expects a 4-4 decision, which would affirm the positive decision of the 3-judge federal court, the lower court, which go to 3-0 in our favor. She expected to have a win, but as was mentioned a few moments ago, she didn't consider that to be a win. She considered that to be just let it ride kind of thing. My expectation was okay. You know, we've accomplished this. This is good. I enjoyed my time in the courtrooms, and one of the things that Ruth and I did is we had a fairly close relationship while it was going on, while the case was going on, and I was made a CC in all the correspondence that came through her about the case and things like that. And I always knew what was going on. I got copies of the briefs and things like that, which made me feel that I was right with it. The only thing that really threw me is they sent me a copy of the Social Security law, the whole thing written, which was a huge volume, and told me to read through it and see if everything is okay. And any other questions I might have, which I thought was somebody making a joke. So I really didn't spend any time looking at it. All we really wound up doing was changing the word that said widow in the Social Security laws. We changed it to surviving spouse, and that went through the entire law.
Thank
It was a
you.
wonderful experience.
Thank you. One last question, and I think it talks to the justice's remarkable legacy. The question is, the stories show her patience that we all wish we had. Was it innate, or did she develop this patience over time?
Well, we didn't hear from
Patience
Sharon on the last question, so
You mean when
maybe
you
Sharon.
ask her a question?
Yes,
Go
thank you.
ahead.
And then we'll talk about her
Go ahead,
patience.
Sharon.
You want my answer to the last one? It was that I had every expectation when we went to district court that this was a slam dunk. You know, maybe the guys in the military offices couldn't figure this out, but certainly 3 judges on this federal panel could. And so it was like a 2x4 to the gut to lose that. So when we went to the Supreme Court, I really had no expectation. That I really didn't know what to expect then. Because by then I was 3 years older and a whole lot wiser. Did you want to say something, Joe?
Yeah, I would say this. When it went to the Supreme Court, I was surprised by by our trial court, our 3-judge panel. We had one great and very famous federal judge, Frank M. Johnson Jr., was district judge on the panel. Another very conservative judge, whose name, of course, I'm blocking, from Mobile, was on the panel, district court. And we had Judge Reeves, who was a circuit court judge on what was then the 5th Circuit before the 11th Circuit was created. And he was very moderate. I was surprised at that decision. As to taking it to the Supreme Court, I was very confident that we would win that. I thought it would be a significant win. I was a bit surprised that it went 8-1. I was not surprised at the dissent, but it was, to me, the only real question was going to be whether they would go with with what Ruth wanted them to do, which was strict scrutiny, or they would go with the rational basis test. They went with what we all think of now as rational basis plus a little bit, somewhere in between. But yeah, I was confident that that it was a winner. I did not think that in that era that we were going to have judges who were going to permit the military to discriminate in that way. I should say justices.
Thank you.
I'll ring in for just a second on Ruth's patience. Ruth was constantly drilled by her mother to be a lady, always act like a lady. And every time you talk to Ruth and she was getting restless for some reason, she'd always remember her mother said to her, act like a lady. Excellent advice.
It's one of the things to be mentioned about her patients. She had two former litigators who themselves became Supreme Court justices as her role models for arguing before the court. One was Justice Brandeis, who created something called the Brandeis Brief, which emphasized social realities rather than legal precedents as a way of getting, telling the justices what it was that they ought to be taking into consideration, just as Ruth ultimately talked about to the Supreme Court about how women's status had changed in ways that the justices had to acknowledge, and that it was time for them to acknowledge the fact that women had a right to be in all of the professions and to be treated equally all the time. But the other person who was not yet, when she was arguing, not yet a justice, but who was a terrific litigator, was Thurgood Marshall. And what Thurgood Marshall did in the cases that led up to Brown versus Board was start small, understanding that he had to bring the justices along step by step by step. So he didn't begin by arguing that segregation is wrong. He began by saying, no, if you're going to segregate the races, you have to treat them equally, which he knew was going to be incredibly expensive when it came to law schools and other kinds of graduate schools. And the justices wouldn't say, that no, states wouldn't say that we have the resources to treat these people equally. So taking things step by step, that's what she did. And that is definitely a kind of patience. She was willing to wait as long as she could go on litigating, choosing for the most part the cases she would bring. And then, as she said, taking them to a court where she felt she had to give the justices the equivalent of a second grade education in sex discrimination. And that was certainly a great deal of patience right there.
That was one of her best lessons, is to learn to go slowly and to bring things before the court piece by piece, so the justices and the population can get used to the new ideas. And oddly enough, she always felt that Roe versus Wade was brought too fast and too much what was decided at one time. And she always felt the population would not approve of it. And of course, we don't know about dogs now.
So does anyone
one
else
day
have
we'll-
closing words before I wrap everything up? Well, thank you so much for joining us. This has been a delight. We ran a few minutes over. I apologize. I think we could have you guys go for another couple hours and our audience would still be as enchanted. No good deed goes unpunished, and I may ask you all back. Our next event on the Society's virtual calendar is on April 30th, 2024 at noon. Professor Jose Anderson will be discussing the life of Charles Hamilton Houston. This marks the beginning of our commemoration of Law Day. Registration is open on the Society's website, www.supremecourthistory.org. A reminder that for everyone who registered in advance, a survey will go out later this afternoon. Please do respond. We want to make these programs rich and accessible to as many people as possible, and we appreciate your feedback. Thank you for joining us. We are adjourned.
Thank you.